All right, so today my video is going to be about the bonds. So there were two notaries at this closing, very clear and concise, illegal, and both notaries have a $10,000 bond. So this is how I caught my attorneys. So when they were trying to force me into a settlement with the title company, they were conspiring with Lipson Nelson and Angela Ochoa, who's representing the title company, and the escrow agent, who is also the notary. So they were conspiring, trying to force me into a settlement of $5,000. I told them this was bullcrap. I wasn't going to do it, and to withdraw from my cases on May 21st, 2020. And when I had them withdraw from my cases, then the very next day, Raina Hughes comes out with her journal entry. So the journal entry was a complete fabrication of everything, and it was made to allow the bond companies to illegally deny giving me the bonds. So I will go over her journal entry. It's kind of similar to the divorce decree, but she changed things because it doesn't make sense. So as I read it, you'll see how she contradicts herself several times, and it makes absolutely no sense, but it was just good enough to give to the bond companies to make sure they denied it. So these are her finding facts. On January 8, 2020, wife filed a motion for partial summary judgment. The court granted wife's request for an order shortening time, and wife's motion was heard concurrently with on the February 7th trial. That was filed by my attorneys. Had I filed it, it would have been granted. The court found that the marital questions of fact were precluding the summary judgment. So they held this unnecessary trial on February 7th and 12th after they already knew the deed was invalid. Most issues in this dispute stemmed from the purchase of the marital home. Shortly after the parties married, they decided to purchase a residence. Wife did not have a good credit rating and could not qualify for a mortgage. Nobody ever ran my credit, so they didn't know any of this. So she's just writing stuff. So the husband had a better credit rating, but little cash on hand and some debts, and wife had cash on hand from her foundation. It was not from my foundation. So the wife claimed husband committed marital waste by paying the balance of his premarital student loans of $8,374.03. The parties entered into an agreement whereby the wife would receive funds from the equity of the marital residence in repayment for the separate property contribution. She made that up. How can we make an agreement on equity when there was no equity in the house? So another fabrication. The student loans were required to be paid off by the lender to purchase community assets. I never talked to the lender, never went to the lender, and you guys saw from my other message when I asked the realtor to tell me what the lender was doing, they denied me that. So again, another fabrication in her ruling. And then, let's see. The court finds wife claims she had no knowledge of the husband would need to pay off the balance of his student loans in order to qualify for the mortgage to purchase the marital residence. Wife's testimony was not credible. Bobby provided nothing to her that showed me that he told me about these student loans. The court finds the husband knew a month before closing that he would have to pay his student loans off. He discussed this with his wife. They both knew the lender required the student loans as well as other debts to be paid off in order to close on the purchase of the marital home. Husband ended up paying his student loans before closing, which caused the lender to require an explanation why he was conducting the transaction ahead of time rather than at closing. Well, I proved to you guys they did it at closing. She took it out of the deposit and they did it in escrow. So her ruling makes no sense. She's just making stuff up. So there's no way that he paid them off prior to closing when I have the receipts. Hold on, let me get them real quick. I have the receipts right here that he paid them off 1/19/2018. So no, he didn't tell me. He just paid off these with the help of the notary and the real estate agent and the title company. And why not pay your whole life off and screw me? Because they said they can protect you. So there goes that. The court finds that husband and wife agreed to would provide all funds for the down payment and escrow deposit and pay off certain premarital debts owed by the husband. Wife's sole and separate property funds were used exclusively for the down payment and the escrow deposit, and the husband's auto loan payoff and student loan payoff. So the gift letters, one was for a down payment. Didn't say they could take any money out of the down payment. I thought I was putting $65,000 down on my home. I paid $3,000 for earnest deposit with the belief I would be on the home. I then paid $4,060 for a car payoff. Besides that, I signed nothing authorizing him to pay off any debts, nor did Raina Hughes have anything that authorized him to pay any debts. So the court finds the wife credit prevented her from qualifying for the mortgage, and she was not included on a credit application. I wasn't included on the credit application because they never ran my credit, because I told him in the beginning I wasn't going to be on the loan. I was only going to be on the title. So very clear. The court finds that prior to closing, wife indicated it was not her intent to gift the funds when she attempted to cancel the purchase, even though she was not a party on the contract. So she admits there, I canceled it. But now she's saying, it's my money, but I can't cancel it. So the court finds that closing, wife required husband to sign a letter of agreement acknowledging the funds were not a gift, so she would wire the funds to close the purchase. Another lie. I had him sign the letter of agreement before I signed another duplicate gift letter. So I still did not say he can purchase the home. I said I would sign the duplicate gift letter, and then I wanted to review the information, which again was denied to me. So the court finds wife sent a letter of agreement. The husband, while he waited at the title company to finalize the purchase of the transaction. I thought she just said we were there together. See, it doesn't make any sense. The parties had not discussed the term of the agreement prior to the wife drafting and sending it to the husband. Thought I was there with them, so how did I send it and draft it and then sit right with them? Doesn't make any sense. But again, we had a whole conversation about this, about I didn't trust him, that people were taking advantage of me, that I didn't want the house. So she's a liar. So the court finds the wife communicated to the husband she would not wire the funds to close the sale if he did not sign the letter of agreement, agreeing she would receive $75,000 from the equity before equal division should the parties divorce. The court finds that at trial, wife claimed she did not know she was wiring funds to close the sale. The court finds wife's testimony not credible. Wife was at the title company with the husband, then left to go to the bank and wire the funds. A wire transfer form is required to complete completed at the bank, which the wife did. Bobby said I wasn't there. Linda Knott said I wasn't there. So Raina Hughes, where did you get I was there? But this is how easy it is for our court system to lie and make up whatever they want. The court finds that prior to wiring the funds, the wife sent a text message to the husband that she was sending the money, that she would sign a quitclaim deed and go to heaven and be with her son. Yet at trial, the wife maintained she did not wire the funds. No, I didn't. I went there with the instructions, and I believed I was going to review documents. When I left the bank, my money was still in there. So no, they illegally wired the money out of my account. They misrepresented in saying I would be on title. This is all very clear and concise. The court finds wife asked for a divorce the same day she drafted and signed the letter of agreement and wired the funds to the title company to close the transactions. Wife also claims she was shocked a couple days later after she wired the funds to find the funds were actually withdrawn from her bank account. It's difficult to find the wife's testimony credible, and the court does not. Well, what about the messages where he said, I wasn't at the title company? That wasn't enough? But the purpose here is to deny my justice, not give me any justice. So the court finds the gift letters for $3,000 for escrow deposit, $4,060 to pay off the husband's car loan, and $65,000 towards the purchase price. No. $65,000 towards the deposit. So she just wants to play with the words and make it fit her and relieve these companies of what they did to me. The wife did not meet the burden of proof when she commingled her separate property funds and did not intend to gift to the community. Wife did not meet her burden of proof that the husband misappropriated wife's separate funds for his own personal benefit, even though he paid off thousands of dollars of his debt with no gift letter. That wasn't enough proof. So husband established the savings prior to the marriage and had funds in his account of $13,000 in his Goldman Sachs savings account before he made any deposits. So, like I said, he had his own money. So he said he was using his own money when he was paying his own debts. So the Goldman Sachs was only accessible online, meaning I never had access to it. It was his savings account online. There was no card. So The husband first deposited into his Bank of America account, then moved it to his Goldman Sachs account. Husband similarly deposited wife's separate funds of another $15,900 into his Nevada One account. So she's acknowledging all my money went into that account. Separate property placed into joint tenancy is presumed to be a gift of half interest in the other party unless the presumption is overcome by clear and convincing evidence. Well, the fact that he went to the closing without his wife and my name was forged should be clear and convincing enough. The parties used husband's American Express card for multiple transactions and entertainment. I never had access to his American Express card or his bank account. Nothing. I was never on anything. And I also showed her my personal bank statements that showed her I was using my own card. So husband then paid his credit card from the commingled funds. Husband did not commit waste or misappropriation of funds for his own benefit. The charges on his credit cards were community in nature. Yet I proved to her there was times I was out of town, that I was at my mother's house. So no, Bobby was having a free-for-all by himself, with his friends, with my son's money. All property of the spouse owned by him or her prior to the marriage is his or her separate property, except for anything that belongs to me goes to him. So she's saying all property owned by the spouse. So all my money was before the marriage. So why am I getting nothing back? So he said, wife must demonstrate that the husband made false representations or misrepresentations in the past or existing fact. With knowledge of belief, the husband that representation is false and that the husband lacks sufficient basis of information to make the representation. Well, he says, I wasn't there. He didn't know I was on the deed. So these are all clear facts for Raina Hughes, but the whole point here is just to make sure I get no justice. So the husband did not commit fraud upon the wife when he purchased the marital home in his name alone. The grant bargain deed of sale wife signed at the closing transaction was required in the lender in order to vest title into the husband's name. Wife claims she did not sign the deed, but her testimony is not credible. Well, ma'am, my testimony is absolutely credible because, first of all, I have an expert. So I got an expert, a court-certified, board-certified expert, to then again say it wasn't me. But what should have been enough is the fact that the notary notarized her own document. That should have been enough. But, of course, that wasn't enough for Raina Hughes because her whole goal is to make sure I get no justice. So it gets funnier. So wife claims she did not sign the deed, but her testimony is not credible. Wife signed the deed before a notary, the same notary who was also the escrow agent. Wife has then sued the notary and the realtor who sold the parties of the home. Exhibit Q, bargain deed of sale. It was the parties' intent to vest title in both names after the transaction closed because as between these parties, the marital home would be a community asset. A lie again. Why would we wait till after? We would have to refinance the home to add me on the home. So if I was already there in the beginning at the title company with them, why wouldn't we just put me on there? It has nothing to do with credit. So the husband never intended to exclude wife from ownership of the home. He always considered it their home. But you can see he was kicking me out. He was changing the locks. He threatened to sell it. So no, it wasn't our home. The title was never changed because the time of the transaction closed, serious marital discord existed in a large part due to the wife's distrust over how the transaction was conducted, although there was nothing illicit or fraudulent that occurred in that transaction. So she's saying that the transaction ruined our marriage, but nothing bad happened in it. So it's just ridiculous. So the terms of the transaction were not dictated by the husband, but by the lender and the title company. Both I never spoke to. Never spoke to the lender, never spoke to the title company. Only Bobby did. Still, wife places all the blame on the husband and the realtor. Husband made no marital misrepresentations to wife to obtain her signature on the deed. No, they forged it. I never signed it. The lender required the deed in order to keep title to the property clear and avoid any community property or spousal claims of interest. So they just said the lender decided not to put me on the title. But it was never disclosed to me. So, however, as between the parties, they agreed it was community property. The single fact of the husband not executing a deed to convey community property interests to the wife is not fraud. So he used all my money, he lied to me, and put it in his name, but Raina Hughes says this isn't fraud. Husband always acknowledged the wife owned an equal interest in the home. Unfortunately, the marital discord resulted at the same time the purchase was occurring, so title never transferred. The house should have never been bought. I told her to cancel it. I could have annulled the marriage, and I wouldn't have gone through 3 months of pure hell. 3 years. 3 years of this. So, trial issues. $1,300 garnished from the parties' 2017 joint tax return for a past due child support obligation. Wife did not agree to pay his child support, and he's only required to give me half of it back. The wife's medical expenses incurred due to husband removing her from the insurance. The wife provided insufficient evidence at trial for these expenses. Well, let's go back to what she removed at trial. And we'll go right back to the end, because here you will find, again, Raina Hughes is just a liar. All the bills, all the medical bills, all submitted to Raina Hughes. So, all of this, I didn't meet the burden of proof, fabricated. So, the wife's personal property was damaged when he removed the items from storage. So we went over this again yesterday about what he did to the items in my storage. So I will go back and show you again what this man did to the items in my storage. And remind you, this was all uploaded to Raina Hughes 2 years ago. So she's had all this information of the abuse. So this was what my body looked like from the stress. The constant stress of being kicked out of my home, of everyone lying and stealing from me. So, let's see. But it's very sickening to me that it's this easy for a judge to say whatever they want. And it doesn't matter how much evidence you've turned in or how honest you've been with people. The judge could say whatever they want because there's just a judge. So, again, there was no damage to my personal property. Damage to my home. Damage to the outside of my home. And damage to my furnitures. So this again is Raina Hughes saying I'm not credible. But I'm sorry, Raina Hughes. The only person not credible here is you. So this is all damage this man did to my storage and my belongings. But yet she removed all this evidence and then said I didn't have any evidence. So let's see. Wife incurred a lease break fee for her lease agreement for the apartment she rented prior to the marriage. Wife shall be solely responsible for that obligation, and this is her sole and separate debt, even though I proved he lived there for 3 months. And then the wife underreported her income, which resulted in an IRS tax obligation for the wife. Again, a lie. So whatever paper they have, it's never been given to me. And then I requested a paper from the IRS, and I uploaded that. You guys see, they say I owe nothing. And I also outsourced my taxes in 2017. Didn't even do them. My CPA did them. So if there was an issue with them, my CPA would contact me. So it's a fabricated IRS debt that they made. And they still have not given it to me. And didn't upload it in any of the evidence. Weird. So the husband requested reimbursement from the wife for mortgage payments, HOA fees. Husband paid marital residence while wife lived there exclusively. All a lie. He used my money the whole time he was living there to pay things and then said, oh, it came out of my account, I paid it. No, all lies. So the husband requested a reimbursement for charges to his Bank of America card for his wife using it for her nonprofit. Wife did not spend these funds for the community, but made a contribution to her separate property foundation, which she should reimburse the husband, and in the manner above, in which he has committed credit card fraud. Well, let's look at this credit card fraud. Here's Bobby sending me the credit card. No worries, the number's been changed. Here's Bobby sending me the credit card. And here's Bobby telling me it's free to use it, no problem. So, mind you, this is the only thing he ever let me do. And I did it to buy a hot dog cart for the foundation. That's why I did it. And he told me I could do it. But leave it to Raina Hughes, I commit credit card fraud. So really, it's that simple. It's that simple for a judge to say whatever they want and then deprive you of justice. But this whole opinion of the court that was done on May 22nd, 2020, is when I first found out what the heck happened. Trial didn't go right. So I tell my attorneys, and then I provide them 7 days later with an expert that says, okay, if she didn't believe anything, here goes the expert. They refused to give it to her. She refused to hear it. So then I was going after the bond. So here goes Liberty Mutual. Notice the date, July 7th. I found the bond. So, no, wait. No, I filed it April 9th, before her ruling. So, what she did was, she drafted this entire journal entry to allow Liberty Mutual to then completely deny the bond. And you know how they denied it on July 7th? With Raina Hughes' fake ruling. And they completely ignore that this notary, Nikki Secaucus Bott, notarized her own document. Clear fraud. Not only that, I reported it to the Secretary of State. You can see here it was reported in 2018. You could also see here that I gave them the information, notarized her own document, and I told them she forged my name. Well, all the Secretary of State did was say she didn't turn in her journal, charged her $250, and closed the complaint. Now today, the very same person from Secretary of State that concealed it in 2018, Lenora Mueller, refuses to take the letter from the expert, refuses to acknowledge that there were two notaries at the closing. Two. So this is the deed of sale. So Bobby's saying he didn't know I wasn't on it. Well, when he signed it, you can see right here, Bobby Ante, a married man, as his sole and separate property. He was very clear of what he was signing. So then go to the back of this. Notary, Melanie Traynor. Why would there need to be two notaries? So if you are married, you cannot buy a home without your wife present or your mate present. You cannot buy a home without them signing a quitclaim if you're both not gonna be on the home. Can't do it. But they continue to do it. So Raina Hughes puts in this fake ruling. Liberty Mutual then takes her fake ruling, denies the bond. Then Melanie Traynor's bond company does the same thing, just denies the bond, even though there's two notaries. And if you notice something else about these two notaries, they live on the same street. So why would two notaries that live on the exact same street be at one closing? Besides the fact I didn't show up, so she called her neighbor, who she knew was a piece of shit, and would come fraudulently convey title into Bobby Ante's name, and she did it. And they all sat there, Melissa Parker, Drew Levy, Linda Naw, and Bobby Ante, knowingly fraudulently conveyed title into Bobby Ante's name. Bobby Ante fraudulently accepted conveyed title into his name. This is mortgage fraud. NRS 205.372. Anybody that conceals mortgage fraud is guilty of mortgage fraud. So now, because this RLJ insurance company denied the bond, had clear and concise evidence, they're concealing mortgage fraud. Liberty Mutual, same thing. Clarissa Nell, she is the agent. I gave her the letter from the expert. I gave her all the text messages. I gave them everything. And then they simply just say, no, we're not going to give you the bond. So this is how we're treated in the legal system. Even if you're right, even if you're doing everything you're supposed to do, even if you're submitting all your evidence, this is how easy it is for them to deny you justice. So, one last part of this video, responded docs. This is how I found out that my name was forged. Bobby Ante had already retained Shumway Van because Linda Na sent him there. So when I filed a complaint to Galvar, Linda Na and Shumway Van responded in their documents. So you can see here, this is Linda Na, November 20th, 2018. She's responding. In her response, they provide proof of forgery. You can see here, Shumway Van is preparing this on her behalf. They don't mention anywhere in their statements that there's a forged quitclaim deed. Not even when we went for exclusive possession did he say, hey, she signed a quitclaim. That's why my name's on it. They just ignored that. So they then write statements, Linda and Bobby, and they lie about everything. So I'm reading these statements and I'm like, hey, wait a second. That's not how any of this happened. So I then tell my attorneys and they do nothing. So Bobby also writes a fake statement and submits it to them on behalf of Linda Na. So now this is December of 2018. But you could clearly see in June of 2018 when I first found out, he was all about, he was sorry and he didn't know I wasn't on the deed. But now in December, he's writing statements on the behalf of Linda Na to Galvar saying I knew the whole time. And then this is where I first saw the forged quitclaim deed. This is the first time I saw it. Right here you can see respondent docs. Respondent docs. Therefore, the fraud was told to me by Shumway Van, Bobby, and Linda. They then go and file a fake case, a fake frivolous case that has now been going on for 2.5 years because she said I have caused defamation to her. So not only did she steal from me and try to put me through years of endless litigation, she then sued me and tried to steal from me again. And then tried to use all her little lawyers and her little friends to do it. And Bobby was a piece of shit enough to want to save himself. So he had no problem at all lying, defending these people, watching them steal from me, and now watching me and my mother be thrown out of a home that I've been forced to solely pay for, that I was forced to solely buy, and been forced to live in. And now I know I am entitled to quiet title. I am entitled to my restitution and damages for everything that's been done to me. So I don't care how much these judges feel like they are above the law. I will keep exposing it until I get justice.